So I'm going to move on to our next speaker, who's David Joe. David is a former chief negotiator for Council of the Yukon First Nations. Mr. Joe is Yukon's first Aboriginal lawyer. Both prior to and after being called to the Yukon Bar in 1976, he was intimately involved with the land claim movement in the Yukon. In 1973, he was involved when the Yukon First Nations convinced then Prime Minister Pierre Trudeau and then Indian Affairs Minister Jean Chrétien to negotiate a modern-day treaty for Yukon First Nations. Mr. Joe was still involved in this 22 years later when the first 4 agreements became part of the Constitution of Canada on February 14th, 1995. Today, the recognition of Aboriginal rights is still a focus for his Whitehorse law practice. And in 2008, Mr. Joe was named Order of Canada Officer. Welcome.
Well, thank you very much. It's good to be here in Ontario First Nations unceded territory. Thank you for asking me, IOG. Just in terms of my background, I'm of the Champagne-Ajac First Nations from the Yukon, but we are a little bit schizoid in the Yukon. We heard from the speaker from INAC, who basically said there are 2 streams. One for those First Nations with agreements on self-governments. Then there are those under the Indian band structure. Well, in the Yukon, we've got 14 Yukon First Nations, and 3 of whom have looked at the mandates, have looked at the respective offers from both Yukon and Canada, and basically have said, thank you very much, we're not about to accept your mandating offer, both with respect to treaty making and or self-government. So they've opted out of the process, but they are involved with the Assembly of First Nations through their own unique processes. Now for my First Nation, we have traditional territory in the Yukon, which was ceded pursuant to a treaty in 1995. And we also have an agreement on self-government that accompanies that modern-day treaty. And so today what I'm going to do is reflect more on where our First Nation, with an agreement on self-government, what that current status is. So they told me that oh, it works. What I'm going to do here is just explain 2 things in terms of a background summary. Within the treaty-making process in Yukon, we have 16,060 square miles of Aboriginal title lands that are equivalent to fee simple, that we share amongst the 14 Yukon First Nations in some form, some fashion. So we have land. We also have jurisdiction. We have the exclusive authority for all things that are conveyed within the treaty agreement. If my First Nation wanted to cut me a check, not that they will, for the entirety of their land claim funding amount, which is about $100 million, they have the exclusive authority to do that. So they have the exclusive authority to determine what happens on their treaty rights. Also, they have the exclusive authority over their internal functionings. So they determine if they're going to have an executive council, what body of their government is going to be the legislative branch, and they also have the ability to establish peacemaker courts or First Nation courts that has the right to adjudicate in respect of all of their laws that they may decide to pass, both statutory laws and or customary laws. Then lastly, they also have the paramount concurrent authority over their citizens throughout the Yukon territory. So it's not confined to the 16,060 square miles of land. It's not confined to their traditional territories. If Champagne-Ajac, my First Nation, were to pass a child care law, that child care law tracks with me throughout the Yukon Territory, and it's paramount over any other competing territorial or indeed First Nation law. To the extent that we can't resolve the conflicts internally amongst the First Nation laws, in the event that there's families that have children from two separate First Nations, two different parents, then there is an agreement to resolve it by principles of private and international law. Also, we've got paramount concurrent authority over all land matters on the 16,060 square miles of land. However, on taxation, basically on the 16,060 square miles of land, we have agreed to share concurrency of tax room so that we have to enter into tax sharing accords. So against that backdrop, we know we got land, we know we got jurisdiction, as I've explained. Now the question becomes, how do we exercise that, and what's the amount of resources that we've got? And what this slide shows is that we've identified, or have attempted to identify, the source of funds for First Nations with agreements on self-government. So if we go through the list very quickly, of course, within the treaty we got compensation funds. We also have an agreement within the treaty on resource sharing. I believe it's the first one of its kind in Canada, and I'll be speaking a little bit about that. We also have what are termed strategic economic development funds, which is a separate pot of cash to ensure that First Nations with these agreements participate in the economic mainstream. We also have funds, you want to maintain the viability of the treaty payments when they were crystallized. That basically means that for Champagne-Ajac, our effective date for the treaty was Valentine's Day 1995. Some First Nations came later, but the amount of compensation from the collective pool had to retain its basic economic worth. So we had to re-index some of those funds to make sure that they got the full value from those funds as well. And then there's the so-called Section 87 funds, because most of our citizens, about half of them are, pardon the expression, non-status, and many of the First Nations in Yukon did not have reserves. We decided from a perspective of parity and equity to forego the tax exemptions that are currently conveyed under Section 87 of the Indian Act. So in return, we receive compensation, and there's a formula as to how we would share that amount of compensation. Also, we also have funds for training trusts that are conveyed as part of the treaty. One of the issues that I heard here was capacity, that there is need for capacity development, and we recognize that we do not have the capacity. All 11 Yukon First Nations do not have the capacity to assume all of the full responsibilities, both under their lawmaking regime and to basically staff up entire governments to take on these responsibilities. And so we've tried to make sure that we've had training trust funds as well. And then under Chapter 22 of the treaty, we've got a number of economic rights that are built into the treaty itself, and I'll speak a bit about that. And the example that is used up there is special guide outfitting opportunities for sheep within one of the game preserves in the Yukon. And the sheep hunting goes at a pretty exorbitant cost. American hunters usually bid on the right to take a large ram within this preserve, and usually the cost is about 100,000 American to just not to take a sheep, to get the opportunity to hunt world-class sheep in the Yukon. So all of the First Nations have identified what is unique to them And for the purpose of Tla'aani First Nation, that is one example. And of course, we have a number of tax sharing agreements. We've got 11 of them in the Yukon Territory, and that's basically to share income tax at this point in time. We're attempting to get an expansion of all of the concurrency of tax rights, including corporate taxation, all of the sin taxes, alcohol, tobacco, et cetera, but we need agreement from Yukon and Canada to allow us to occupy those tax rooms as well. And of course, the vehicle of choice that the parties have agreed upon are financial transfer agreements, as they are so called, and they are established under the terms 16.1 of our agreement on self-government. And then all of the ancillary programs that go with it, programs and services. As we know, there's a number of status programs that are currently existing out there. And instead of occupying the field, drawing down a law, getting the money from Canada, including them within a fiscal transfer agreement, we basically have said there ought to be an interim transfer of these monies through a program services transfer agreement. And as you've heard, CFA funding is used to fund many of the existing programs, and as a rule, they're only for status people. Now, on compensation, because there was one collective pool of compensation in the Yukon, how do we share that? We got about $242 million in 1989 value, and we decided 1/3 of that pool would be shared collectively amongst the First Nations. So all of the First Nations got 1/14 of 1/3 of that pool, and 2/3 per capita. So in my case, Champagne-Ajac has about 1,200 citizens, and if you take that 1,200 as part of the total number of Yukon First Nation citizens, that gives you a percentage. That is our 2/3 share of that particular piece of the pie, and that's how we worked out that formula. Now, on resource sharing, basically we share 50% of the first $2 million and 10% thereafter. This is on all so-called Crown lands in the Yukon Territory. And the resource share, we share it in the same manner as compensation, 1/3 equally and 2/3 per capita. Now, although there is, this agreement is entrenched as part of the treaty, we do have a subsequent agreement with Yukon, and once they assume the authority over Crown resources, they have agreed to share an additional 15%. So currently we're up to about 25% on all Crown resource sharing in the Yukon Territory. There are some threshold requirements that we have to meet, but basically the principle is that we've got access to resource sharing. Now, on economic development funds, all I want to say here is that you've heard the chief speak about the fact that we have to be involved in the economies of our respective territories, and all this fund attempts to do is how we would rationalize that inclusion. How to re-index the funds, I've spoken about that issue. You want to maintain the value of your treaty funds going forward, and there are a method and a process for resolving that. But be aware that when you re-index, the mandate for that process is circumscribed in terms of time by Canada. They basically say if Yukon First Nations want a treaty, you have to get on the boat by March 31st, 2002. If you don't, then we will not re-index your funds after that period. So that is an issue and that is a problem. On Section 87 funding, we did get compensated to the amount of $26 million in 1989. A notional number, we thought we were kind of shy on that, but the sharing of that money is pursuant to a formula that has been agreed upon by all Yukon First Nations. On specific claims, basically the treaty does not extinguish any spec claim rights that you may have with respect to your territories, your lands. You still could file those claims. And the example that I've included up here is 21st Nation were excluded from accessing their traditional lands within Tlawani National Park in 1940, and that continued on for about 26 years. They were compensated for that loss of use, and this money was rolled in as part of the treaty payment to them. Training trust, suffice to say here again that we do have these funds there, and it's intended to build up the capacity of First Nations citizens. And there are some issues about training because we are competing on a labor market scale with both Yukon and Canada. We cannot afford to basically meet the wage and salary scales of both Yukon and Canada in the Yukon. We don't have that kind of resource capacity. And there's always competition for good people, as we know, and we want to ensure and maximize the opportunities that our citizens would have as employees in locations of their choice. But boy, it'll be good to keep them home on the res. And so we try to train them up, and we do that, but there's no security of ensuring a retention of that labor market pool. Now, on economic rights, all I want to speak about here is that in the Yukon, within the final agreement, we have the opportunity to back into strategic development as it occurs in the Yukon Territory, so that if there's a hydro project, for example, we have the right to back into that hydro project to the extent of 25% equity. And so if Yukon decides to build a hydro extension, a new dam or something, that new project allows us to back in, and we've exercised access for this right as well. And then there are other opportunities so that if Yukon were to sell an asset, we have the right of first refusal to buy a governmental asset over the estimated amount of $10 million. Likewise, we have the right to buy any other assets within the respective territories that may be over $2 million. And if a project creates more than 25 full-time jobs, for example, a new mine within a First Nation territory, we've got the right to back into that project as well. Now, on FTAs, what I want to say here is that on financial transfer agreements, that is currently the vehicle of choice to deliver all of the funding to Yukon First Nations to run all of their matters. In the case of Champagne-Ajac, we get about $16 million that is rationalized through a financial transfer agreement. And so that funding is secure over periods of 5 years. That term we think is a bit short. We think it should be a longer period of time. We think the appropriate period of time is maybe 10 years, 20 years, but 5 years is currently what we've got. And additionally, to the extent that we do not want to assume a program and service within a financial transfer agreement, we would have the right to run or to adopt a program service transfer agreement on its own as a standalone contract. So for Champagne-Ajac, the example is that we've got $16 million. About 1/3 of them are PSTA based, simply on program and services that we run through this program. And there's many problems with that approach because it doesn't assure funding, security over that period of time. Now, the question was asked, do we have, notwithstanding that backdrop, notwithstanding the amount of land that we have, notwithstanding all the rights that we've secured in the treaty, notwithstanding all of the amount of the access that we have to funding as I've outlined, is that sufficient? The simple answer is no, it's not. And why is it deficient? Well, one reason is that the money, when we assume the agreements, were only for status Indian people. They did not include all of our citizens, so that in the case of Champagne-Ajac, for example, we have responsibilities for all of our citizens, including those that may be considered to be non-status. So we got status and non-status as well. So the funding is only for half of our citizens, whereas it should be for the totality of our citizens who would qualify for the claim. Also, when we took over the agreement and the infrastructure and housing that we inherited from INAC, all of the infrastructure and housing were built to very deficient, inadequate DIA standards, and on the effective date of our agreement, we had to assume responsibilities for all of this infrastructure and all of the housing, deficient infrastructure that existed at time of the effective date of the agreement. So we had to upgrade all of those facilities on our own and continue to do that. And we also inherited all of the problems with deficient housing, especially in the Yukon, in which it's pretty hard to maintain decent housing in the Yukon. So as part of the financial transfer agreement, there is no catch-up with respect to any deficiencies that existed for your assumption of infrastructure or housing. There is no way to catch up to national building codes that are currently within the funding base as part of our FTA agreements. So that creates a huge gap issue with respect to the maintenance and the quality of those facilities that we've got. And there's no gap closing as well. We've heard that the mantra of Justin Trudeau is that there ought to be gap closing, i.e. we are at the bottom rung of every socioeconomic indicator in the Yukon Territory. Our children have the least amount of good schooling. We have the most suicide rates. We are most likely to die at a certain age than the rest of the population. Every socioeconomic indicator tells us that we need some ability to close these existing socioeconomic gaps that exist between us and the rest of the Yukoners, and indeed the rest of Canada. And also, as part of this, all of the existing funding that we received were simply on a status headcount. How many status Indians does Champagne-Ajac have? We got 600. Here's the per capita allotment approximately that you're going to receive. And again, it is not reflective of the amount of citizens that we've got within the First Nations of Canada. Only because Canada basically says we only have responsibilities for status Indians under 9124. As we all know, the Supreme Court of Canada and Daniel said that is not true. You also have responsibility for Métis and for non-status as well. We're looking for ways in which Canada will now respond to this new edict and mandate that has been instructed by the Supreme Court of Canada. And of course, I went through the list of funds that Yukon First Nations generally have. And Canada, every time we attempt to rationalize or include additional funding, they basically look at those listing of funds that we've got on compensation, economic rights, whatever it may be. They say own source revenue offsets. You Indians are going to have to pay your fair share, and you've got a lot of money out there, and we want you to rationalize any investments that you have made with respect to your investments and participate within that process. Now, what is wrong with that? Well, generally speaking, not much from a conceptual point of view. However, I would argue that it's wrong to deduct OSR when the socioeconomic gaps still continue to exist. So it would be wrong in that respect, and those were the submissions that we have made, but they have fallen to date on deaf ears in that regard. And gap closing is basically set off due to any sort of OSR offset considerations. So we don't get the gap closing. It's basically slowed down because of the initial consideration of paying your own way. And every time there's a new program announced by Canada, like $12 billion for infrastructure in Canada, what is our share? Well, guess what? All of the money in Yukon goes to the government of Yukon and or to the provinces, and our share we have to go hat in hand and rationalize with the territories and provinces what our fair share of that amount of that funding could be or should be. We think there ought to be direct access to that funding through Canada. Now, there's also a lack of what we term keep-up funds. Once we've maintained the infrastructure and the buildings and maintaining the standards that are generally acceptable from a socioeconomic perspective, how do we maintain consistency and sufficiency of those funds? Those we've termed keep-up funds. We need access to those funds like anybody else, and those funds should not be coming with a cap in regard to that. Now, one of the issues on housing is that Canada takes the approach that First Nation housing is based upon market housing. Market housing is great, but First Nation citizens, generally speaking, cannot pay for the upkeep and the maintenance of their houses. And so when we got these transfers on the effective date for all of the houses on our settlement lands, they came deficient, and as a result, we are stuck with this policy of Canada saying that First Nations still have to pay, but many of our houses come with social housing constraints. It's people that can't afford to live that we still have to maintain that responsibility for. And yet Canada says if you were to assume any housing control, then you're going to have to build in a factor dealing with market housing. And the last, probably one of the last points on this issue on barriers, we in the Yukon, under Section 16 of our agreements on self-government, have attempted to copy the constitutional rights that provinces have from Section 36 of the Constitution Act to assure that they have access to resources in Canada as provinces. Now, Section 16.1 of our agreement basically reflects that type of principle. But nationally, there is no such constitutional comparative, if I can call it that provinces have to share in the collective wealth of Canada. We have no comparable Section 36. Yes, we in the Yukon have a Section 16.1 through an agreement, but that's a contractual assurance. It's not a constitutional assurance. So we have to sort of upgrade or increase that. So what should a new fiscal relationship look like? First thing is that I think it requires a constitutional basis under a revised Canada Act. I noticed that Quebec is now talking about trying to initiate or reinitiate the constitutional process. And of course, we are going to have to get our shopping list in line and agree on what that will look like collectively. And my submission is that we need something from a fiscal policy point of view to assure that our rights exist outside of simple contractual rights, but find a foundation in the constitutional law of Canada. We don't have that degree of security yet. Also, in terms of, we need financial transfer agreements that are longer term. 5 years, Champagne-Ajac, my First Nation, our most recent agreement expired. The last agreement that we got was in 2010, expired in 2015. We are now moving very quickly to 2018, and all we are doing are extending all of these deficient FTAs while Canada is attempting to rationalize a new way forward. Also, we have to allow within the agreements, and to some extent they do, by contract, to allow for extraordinary circumstances, we think, within these FTAs. For example, if there's a fire, a forest fire that wipes out a community, can we go back and reconsider what the housing costs, what the infrastructure costs are going to be? I think the answer to that question is yes, there ought to be a way in which we can anticipate those circumstances, and they should be embedded within the various FTAs as well. And there should be no OSR offsets until the gap, the socioeconomic gap that the parties agree exists, have been closed to a sufficient degree, or in some contexts that's acceptable by the parties. Now, it has to be based upon citizens as well, people that belong to your nation, not simply doing a status head count and determining what the per capita amount has to be. And the funding has to include catch-up and keep-up to account for all of the insufficient infrastructure programs, housing programs, as the case may be, and ensure the viability of keep-up through monies that are payable each year into a reserve fund, so you know you got the capacity to replace those essential community services and housing as they are required over time. And the money has to be direct. It has to come directly to the First Nations from Canada. It should not be filtered through the territories or the provinces, through INAC. It should be a direct payment from the Crown to First Nations. Also, there has to be more tax sharing rooms. We can't go hat in hand every 3 or 4 years to Yukon or Canada and say we have to grow our tax room. Currently, we've got responsibilities over personal income tax for people that live in the Yukon, 16,060 square miles of land. But what of the corporate tax? What of the alcohol tax? What about the tobacco tax? All of the sin taxes? And what about sharing some of the other tax rooms? Currently, there is a reluctance by both Canada and Yukon, in our case, to share that degree of tax room as well. And I do believe that's it. And so in very summary form, that is clearly sort of part of the Yukon experience, and hopefully it would be of help to you all. So thank you very much.